Good afternoon, everyone. This is Steve Wilkes. Thank you very much for joining us today. I would like to extend a welcome on behalf of the Wagner Law Group. Glad you're all here to talk a little bit about social media. I believe that you can see the agenda for today's webinar. I think we'll run about 20-25 minutes at the most. I'll have a few introductory remarks. We'll talk a little bit about the the types of social media that are out there. A little bit about the regulatory framework, as sparse as it is, which is currently in place. What the SEC and FINRA have to say about it, and really what the DOL hasn't said about it, but we think is something that may come up as an issue over the in the foreseeable future. And then we'll conclude with some action items that you might want to consider. So I think the goal today really is for those of you that are in the investment advisor, broker-dealer community, or maybe a regulated financial institution, to think about your regulatory compliance, the use of social media by your firms, and how that content and those efforts are currently directed in the retirement plan service and retirement plan product space, because we see them coming together. A little perspective on today's webinar, again, in terms of some introductory comments. What we're seeing in the ERISA marketplace. Generally, we all know that there are many internet users out there in our business communities. 70-75% of the internet users, based on one recent poll I saw, are using social media. The number of advisors and broker-dealers and financial institutions that are engaged in social media has lagged that number a little bit, and that's because I think of not that you or they are afraid to use social media, but a little bit of uncertainty about exactly how it's going to work and what the compliance might look like. We do see that the social media is being used for primarily in the realm of business development and marketing, and this could potentially can bleed over to investment advice or advertising, performance reporting, product information, other things like that. So it's something that we really need to take a focus on, again, thinking a little more about the ERISA lens. In terms of our law firm, we're getting questions about social media from our clients, and what we typically do is we either work directly with a client or very oftentimes working with the client's consulting firm if it's more efficient to go that way. So we're seeing these issues are definitely on the rise. I do want to point out that we do have some information and guidance about electronic disclosure. The SEC has spoken in the past, the DOL has spoken in the past about the use of email or posting information on a website for purposes of 408B2 disclosure or participant disclosure under 40485. There's some different rules. It's not quite settled. It's still evolving. And that's a little bit different. That could be a webinar topic of its own. But today we're going to talk more about the social media aspect of it, which is not as evolved. I think that given the best practices and the regulations that we could look to, probably the SEC and the investment advisor framework is about the most evolved and the most helpful at the moment. So we'll talk a little bit about that. Again, knowing that that's maybe a benchmark at the moment that we can consider in terms of where the ERISA world may bring us in terms of social media. And then I'll try to have some specific action items for you when we're done. And by the way, we're going to talk today kind of from regulatory, kind of compliance mindset. There are a lot of other implications involving social media that we're not going to get into, but I know that you're all aware of them. Things like intellectual property rights for using other people's data, maybe some privacy issues depending on the kind of information that is exchanged about clients, to the extent that it's a recruiting tool. There could be employment law implications, but those are separate conversations to be had. There are different kinds of social media. Obviously, it usually is referred to, it usually means some kind of electronic communication where people, create an online community of some sort where they can, share information or personal messages or, reference, content to each other. And I think with the technology that we have today, the number of creations that can be made in terms of different kinds of platforms and the potentially large size of the audience is really staggering when you stop and think about it. There are different kinds of content, and I think the regulators sometimes obviously will distinguish between interactive, static, and third-party content. Static content is just that. It remains visible to a user, for an extended period of time. Interactive contact is more of, short-term communication blasts back and forth among several parties, and third-party content is maybe you have the ability to, through a hyperlink or posting a message or somehow connecting, you have the ability to get, you're either posting third-party content or directing people toward someone else's site. And obviously it's possible to have all those different kinds on there. I think the most common examples that we see, and it's very common out here, I think in our world of advisors and broker-dealers and attorneys and other kinds of service providers, LinkedIn is very prevalent, and we're seeing a lot of LinkedIn activity in the ERISA retirement plan space, a tremendous amount of LinkedIn activity. It's used primarily for professional networking purposes, and it's a place where people can post resumes and can recommend other people's work. You can put profiles out there. You can have user groups. I think that there's also the potential on there for for advertisements and what have you. So it's the kind of thing where you can inadvertently. I know no one purposely tries to give advice or do things that are heavily regulated under the securities law, under ERISA, but this is the kind of place where you could easily leak over, and I think it's time for a fresh look at how it's being used. Facebook, pretty popular. It's a lot of connectivity. You have a lot of live chats, which has the potential for some issues, and you also have a place for for sponsored content. Twitter, I don't know how many of you are twittering. That's one of the growing, more popular sites. I think that you have the possibilities here for, again, for advertisements and client communications, inadvertent advice. I can't remember if it was Twitter or stock Twitter. I know that there have been a couple of actions from, I believe, from FINRA on the Twitter side, where some information was inadvertently put out there. It impacted stock price, for in an IPO situation, and people ended up being fined. Of course, blogging has become very popular as well. And again, as I said before, I think what we're seeing typically is, for the most part, we're seeing the promotion of advisory services and retirement plan platforms, if you will. And people are using the social media in this case to, give commentary, maybe advertise, client updates, all kinds of promotional activities for their own firm. Sometimes employees of a firm kind of engage on their own to carry on, maybe not officially sanctioned by their firm, but on their own they're engaging in some kind of activity. Or there might be, third-party advertising, tweet, links to Wall Street Journal articles, things like that. We're also seeing a lot of, just internal use, where there's kind of like an electronic network which can be used inside of a firm so employees can share information, firm directories, and maybe questions and answers with portfolio managers, things like that. So I think this is all known to you. There's a lot of activity out there which potentially contains a lot of information about our retirement plan products and services that is something that we need to very carefully keep track of. There's also, I was reminded the other day of podcasts and wiki sites, video sharing. So kind of having said that, we know we have different kinds of social media. We have a couple of different ways to get there that are pretty common in the marketplace right these days. So what does the current, regulatory regime look like? I think, as I mentioned before, I think the investment advisor world is kind of the best place to give an example. FINRA follows pretty closely, and of course, I think the DOL is looking and thinking about how this might trickle down to its own jurisdiction. There's not a lot out there, however. The Advisors Act doesn't really say too much. There's a little bit of guidance, maybe that could be gleaned, or I should say inferred, from the Advisors Act, and you have some, published guidance from the SEC and FINRA. We'll talk about it a little later. So, what are the areas that we'd be concerned about in terms of what we're seeing in social media? Well, testimonials would be one. We know that advisors are not allowed to, publish or distribute advertisements that directly or indirectly, contain any kind of testimony about their services. Now, there are certain exemptions. There are no action letters, et cetera, that are posted that tell us, they give us a little bit of leeway there. But I think that the bottom line is that, anything that is meant to include a statement about a client's experience with or endorsement of the advisor is a testimonial, and that's the kind of thing where you can potentially get in trouble on social media based on what we're seeing out there right now. Past specific recommendations. I think as advisors move more toward maybe creating risk-based portfolios and off of a pure retail platform, there's more advisors are doing that now. So sometimes they might, we're seeing them being asked, well, how have you done for another plan? What did your risk-based portfolio look like based on this investment menu? And we know that there's some pretty serious prohibitions on that. So that's an area that you really need to have your eyes on as well in terms of how your social media is talking about your firm and its activities. I think record keeping is huge. I think clearly under the Advisors Act and under ERISA, there are some very clear record keeping requirements as to the length of time, and we have to keep originals of, and we have to keep books and records of. And if you think about it, the record keeping goes to written communications that are received by to or from the advisor relating to recommendations, any advice given, copies of advertisements and notices and articles and investment letters and what have you, all your internal accounts and books and working papers, and your policies and procedures. So to the extent that we're seeing some of these kind of things leak into the social media world, you need to stop and think about your social media as being more than just a business development tool, but as a kind of you need to think about it more as an official avenue of your firm's communication protocol, and how are you tracking it? And of course, for this audience here today on this webinar, it relates very much to what we're saying about things like target date funds and retirement to or retirement through and lifetime income options, all the topics du jour for in our retirement plan world. I think that it's very clear that advisors and broker-dealers need to have compliance policies and procedures, and they need to address social media. I could have, for those of you that were on with me about 4 or 5 weeks ago, we talked about ERISA policies and procedures. Social media could have been a bullet point on that discussion. I carved it out and kept it separate because I saw it as something of growing, concern that we were getting a lot of questions about. But clearly, the compliance policies and procedures is an area where we're getting more and more questions, and people need to be paying attention. I think the big thing here today, I think the SEC has spoken about it, and I think I'll mention later what the DOL has said very informally. I think just the whole concept of being fiduciaries, or inadvertently being a fiduciary, you don't intend to be, is an important consideration that we've talked a lot about. But you need to think about how your social media plays out. How is it delivered? How are you using it? How could it be interpreted? in light of your fiduciary responsibilities to act prudently. I think this is clearly the area that, from a DOL perspective, this is where they would latch on and throw a hook into the social media world. And then again, finally, there's a tremendous amount of responsibility of regulatory coverage under supervision. The Advisors Act clearly says that advisors must supervise their employees, and I think that it's become pretty clear that there needs to be supervision in place with regard to how social media, is being used. I think the final thing, obviously, and maybe the biggest one, which is why I saved it for last, just generally speaking, is advertising. There are a lot of rules about misstatements or misstating or misleading, in terms of material facts, and advertising is defined very broadly, I think, by the SEC, and this is an area again where we see a lot of potential leakage over on the social media side. So, knowing that those are the topics that tend to be within the purview of regulatory regimes, what do we know so far? We have guidance from the SEC, FINRA, and the DOL. What do we know from the SEC, for example? I think again that's a good benchmark for everybody. Well, we don't know that much. We sure could. We'd like to know a lot more, but we do know that there's nothing really definitive in the Advisors Act, but there has been some published guidance and alerts and what have you. I think it was about 2 or 3 years ago. The SEC came out and they did a huge, what they call a sweep on social media, and that was focused on investment advisors. And they requested a lot of documents at the time that were, relevant for social media policies and procedures. And the things they were really looking for, and again, so just think about this now in terms of your ERISA lens, in terms of your retirement plan products and services. They were looking for, either existing or prospective communications involving your services and products. They were looking for items that related to monitoring or review of those communications, and they were looking for personal non-business use by your employees that might inadvertently leak out into areas that needed to be more carefully scrutinized and regulated. And they were looking at third-party posts to see how you were connecting to other websites and other sources of information. They also, by the way, they were very focused on what kind of education and training was in place for people in terms of social media, and whether any internal disciplinary action had been taken. So as a result of that, so they did that sweep a couple of years ago, and then they came out and they published a risk alert in 2012. I put the link on there in case any of you want to read it, because I think it's really helpful, and it provides some really good benchmarking kind of best practices and some guidelines that I think would play out in a lot of different scenarios. And they, the staff, they made various observations, kind of what was happening in the social media world, and they put out some factors that they felt that advisors, really should consider in terms of whether their use of social media was compliant with the Advisors Act, and whether it made sense. I think in terms of, you can infer from that whether it's, prudent and fiduciary-like in terms of just industry best practices and your responsibilities to your clients. So the main things that they talked about in that sweep, I can just highlight them for you. They talked about, advertising and third-party content, and they were very clear that everything you do in that regard must steer clear of the anti-fraud provisions of the securities laws. They were very clear that everything that was on social media needed to be looked through the lens of your responsibility as a fiduciary. And this, again, as I said before, is where it's going to come, I think, into play on the DOL side, as they find the time in the future to focus up on this a little more clearly. Very clearly, compliance policies and procedures, and they felt that those compliance policies and procedures, should have usage guidelines and content standards. There needs to be some kind of monitoring in place, content approval, maybe training of people, and just the overall functionality of the website, you know, measured against the potential risk exposure to clients. So they put out a pretty detailed piece, and I think it was very, very helpful in terms of knowing how to kind of manage your social media. FINRA also has had some activity in this area. Of course, their reach jurisdictionally is a little bit different. So, but they've been into it for a while. I think that they, if I remember correctly, I think they actually formed a social media task force about 5 years ago, and they've come out with two notices that are pretty helpful. Back in January of 2010, Notice 1006, they spoke very clearly to the fact that record-keeping requirements would be in place for social media, that it was potentially possible to trigger the suitability rules when you're talking about investments through social media, to the extent that you somehow were deemed to be making a recommendation. They also said that you know, blogging and use of Facebook and Twitter and LinkedIn clearly had to be supervised, and that you need to have procedures in place for those. Those are all, I think, good takeaways. And they, again, think about that in terms of your ERISA products and services, your ERISA clients, and how you're doing in your ERISA marketplace, and what the DOL would say if some of these communications were not quite, you know, as well thought out as they could be. I think they also, FINRA came out with a follow-up notice in about halfway through the year 2011. Just so they just clarified a few more questions on record keeping and supervision and what have you. So they put out a pretty fair amount of guidance. I think that was helpful. And maybe there's more in the future. We know it's on their agenda, but we haven't seen too much from them. Now the million-dollar question is, where does that leave us as ERISA practitioners? You know, in our retirement world that we all share in common. Where does that leave us? Well, as I mentioned before, I think that the DOL has been very good about publishing some guidance on the use of email and websites in terms of disclosures and, you know, getting SPDs distributed and participant statements, things like that. But in terms of the kind of the larger, broader context of social media as compared to electronic communications, they've been silent. We have had a couple of conversations, you know, kind of, you know, incidental, you know, random conversations with some staff, and they are aware of it. They're concerned about it, and I think they have shared very informally with us that clearly they could see the potential where a fiduciary breach could come out of some sort of you know, inadvertent leakage or improper use of social media. So again, that's something to keep in mind. Say, knowing what we know from the SEC and FINRA, you know, how are those standards, you know, put in place for our retirement plan clients. I think, by the way, I think we may, I mean, I don't know, I think that they need to tie down their fiduciary definition first, and I think there could be some follow-up after that. So, you know, where does that really leave us in terms of, you know, what we know today? How do we put something in place when we think about our ERISA practice based on what we know from the SEC and FINRA and the potential, you know, for the DOL to act in the future? Well, I do know one thing. I can tell you, I think we know that there's not a lot of clear guidance. We also know that there has been some enforcement. The SEC has brought a few actions involving fraudulent offers of securities or, you know, inaccurate statements or insufficient statements of product. I think FINRA, as I said earlier, they actually brought a case, and I'm aware of at least one or two that they've settled, where registered representatives, you know, did not notify their firm that they had been, you know, touting a stock on their Twitter account, and this somehow led to the conclusion that, you know, stock recommendations that did not contain, the material or the proper amount of information were being put out there. So we know that there's, not a lot of clear guidance. We know that there is enforcement. What can we learn? What have we figured out so far? I think from, an advisor perspective, a financial institution perspective, broker-dealer, trust department, bank, whatever you are, as it applies to your retirement plan products. I think that right now complying with these published guidelines would really be helpful, taking them into account and seeing how they work for your delivery on your retirement platforms, and sort of consider them as best practices. Obviously, it's very clear that record keeping is important, and so I asked the question: Are you tracking what you're posting on your blogs, and you're keeping records of your social media interactions? Are you tracking what your employees or independent contractors are doing with their phones and their personal websites vis-a-vis the business? And are you having some sort of record keeping or any kind of review in place for that? It may be that to the extent that they're going on to third-party content, that you want to have some sort of footnote disclosure or legend or restriction in place. And clearly, you need to come up with some sort of, or I strongly recommend, as I started to suggest a few weeks ago on our compliance policy webinar, that you really need to have policies and procedures in place that cover all the issues on your retirement program under ERISA, and those that are inferred, if you will, under the duty standard that are more clearly articulated at the moment anyway by the SEC and FINRA. And I think that you need to have a policy and review it and think how it works for you at your company. That ends my comments for today. I think we ran just about the right amount of time. I hope they were helpful for you in terms of rethinking about your use of social media and the delivery of your retirement plans, products, and services. Our next webinar, we're going to do one, I'm going to do one again toward the end of March. And for those of you in the advisor and broker-dealer community that are working with nonprofit clients, we're getting a lot of questions right now. So we thought this might be interesting. For those of you that are expanding your client base and focusing more on nonprofit clients, we get a lot of questions about what else can we do for our management team. And we're going to talk about Section 457F planning, deferred compensation planning for senior management, and how that can be a potential benefit for your client and for you, because it gives you the opportunity to help manage or deal with the investment side of the funds that are put away on deferral. So thank you very much. Please don't hesitate to send any questions that you have to me, or if you have any suggestions for other topics that you would like me or maybe someone else at the firm, Marcia, some of my colleagues, to address for you, please send us your questions or concerns. We'd be glad to respond. Thank you very much.